Government Bills, first reading, Road Traffic Amendment Ride-Hailing Service Bill 2025. Second reading, Secretary for Transport and Logistics. President, I move the second reading of the Road Traffic Amendment Ride-Hailing Service Bill 2025, hereinafter referred to as the bill. With the advancement of technology and changes in travel mode, personalized point-to-point transport services booked through networks have become quite popular worldwide, and Hong Kong as an international metropolis is no exception. The current-term government of the Hong Kong SAR is determined to break the deadlock by introducing a clear legal framework to regulate ride-hailing services, resolving this long-standing controversy. The regulatory framework proposed by the government places the interest of the public first, with the aim of providing the public with a more safe, legal, compliant, and diversified travel choices. At the same time, we will also take into account the business of drivers, attract new blood to the industry, and promote the healthy and orderly development of the point-to-point transport sector, hoping to bring a new atmosphere to the industry. The issue of ride-hailing services is complex, involving multiple factors and different stakeholders, with diverse opinions on regulatory details from all sectors. However, whether the public, the taxi trade, or the ride-hailing platform companies, they all share a very clear and explicit consensus that the government should regulate ride-hailing services as soon as possible. On the one hand, this will safeguard passenger safety and meet the public's travel needs. On the other hand, it will create a healthy competitive environment for the overall personalized point-to-point transport services. When we consulted the Legislative Council panel on transport in the relevant issue in July this year, members unanimously supported the government in regulating the platforms, vehicles, and drivers providing ride-hailing services, and also supported the government in advancing the legislative work at full speed so that regulatory framework can be implemented as soon as possible to respond to the demands from various sectors of the community. Here, I would like to express my heartfelt thanks to members for their support and their invaluable opinions that they have put forward on the regulatory framework. Over the past period of time, we have been working intensively to plan the regulatory framework and draft the relevant legislative provisions, while humbly listening to opinions from various sectors and making rational and pragmatic adjustments to the legislative proposals in the hope that the regulatory framework can encourage industry development while safeguarding the safety of public travel. Today, I'm introducing this piece of bill to the Legislative Council, taking the first step in the legislative scheme through amendments to the Road Traffic Ordinance, but will first establish the principles of the regulatory framework and provide a legal basis for the next stage of work. We will, in the next term of the Legislative Council, further specify the technical details of the regulation through subsidiary legislation. Depending on the progress of the legislation and other preparatory work, I expect that the first batch of licensed ride-hailing platforms can commence operation in the fourth quarter of 2026. To safeguard the safety and rights of passengers, the bill requires that the platforms, private cars, and drivers providing ride-hailing services must all hold appropriate licenses and permits. In future, legitimate ride-hailing services must meet three major conditions, including 1. Booking an arrangement through a licensed platform. 2. The private car providing the service should hold a ride-hailing vehicle permit. And 3. The driver operating the relevant vehicle should hold a ride-hailing vehicle driving permit. Providing ride-hailing services in contravention of the above conditions will constitute illegal carriage for reward, and criminal liability will follow. Under the proposed regulatory framework, any electronic or telecommunications platform providing ride-hailing platform services must obtain a service license. A licensed platform must be a company registered in Hong Kong and meet specified entry threshold, including those in terms of operational experience, proof of financial resources, capital investment, director qualifications, and other aspects to make sure that the licensed platform has sufficient operational capability to provide quality ride-hailing services. A licensed platform must maintain appropriate and efficient services, conduct due diligence on its vehicles and drivers to ensure that they hold appropriate permits, and keep proper operational records and submit them to the Commissioner for Transport. The Transport Department will monitor the operation of the platforms and impose conditions on the licenses. If a platform breaches the license conditions or any statutory requirements, depending on the severity, the Commissioner for Transport may impose a fine, ferry, or temporarily suspend the license, or even revoke the license. Private cars providing ride-hailing services must hold a vehicle permit and take out appropriate third-party risk insurance. When applying for or renewing the permit on an annual basis, the age of the vehicle must be less than 12 years and should meet the relevant vehicle examination requirements. In addition, the vehicle must be registered in an individual's name and can only be used by the registered owner to provide services. And during operation, it must display the identification marks as required for identification purposes. The person-vehicle binding arrangement will help attract people who are genuinely interested in providing quality ride-hailing service to join the industry, and also avoid the emergence of a ride-hailing vehicle leasing market, which would turn vehicle permits into assets with speculative value or lead to the situation of illegal workers as drivers. Drivers must hold a ride-hailing vehicle driving permit to provide ride-hailing service as must meet specified conditions, including being aged 21 or above, holding a Hong Kong permanent identity card, having no serious traffic conviction record in the past 5 years, and completing specified assessment. We propose that persons applying for taxi and ride-hailing driving qualifications in the future can participate in the same simplified written test, and persons already holding a taxi driving license can apply to the Transport Department for the driving permit without having to sit the test again. These measures will help expand the supply of drivers, attract new blood to the industry, and promote the sustainable development of the industry. For taxi drivers who have already passed the test or hold a valid taxi driving permit, they will automatically be qualified to drive ride-hailing vehicles. The above license and permit requirements can not only safeguard passenger safety and interest, but also help create a healthy competitive environment, allowing taxis and ride-hailing services to leverage their respective strengths to provide quality service to the public. Taxis and ride-hailing services are not a zero-sum game. They coexist and complement each other. After the introduction of regulated ride-hailing services, the unique and inherent operational advantages of taxis, including being able to be hailed on the street, using taxi stands located across all districts in Hong Kong, and picking up and setting down passengers in restricted zones, will remain unchanged. While ride-hailing services can release idle capacity through the sharing economy model to provide the public with more diversified choices. We believe that through the introduction of the regulatory regime, a win-win situation can be achieved for taxis, ride-hailing services, and the public. When considering the number of vehicle permits, we must take into account Hong Kong's unique actual circumstances. Hong Kong is a densely populated city with nearly 90% of the public using efficient public transport system for daily travel. If vehicle permits are issued without any upper limit, it is likely to trigger adverse consequences such as traffic congestion, which will affect the ecosystem of the public transport system, or vicious market competition that would adversely affect the overall business of drivers and industry development. Therefore, the government needs to implement an overall quantitative control on the number of ride-hailing services and will specify the relevant number through subsidiary legislation at the next stage. When setting the quota, we will consider many factors, including the public's ride-hailing experience, the operational needs of platforms, the ecosystem of the public transport system, road capacity, among others. The introduction of the ride-hailing regulatory regime will significantly enhance protection for passengers. However, considering that there may still be a small number of lawbreakers using private cars for illegal carriage for reward, the bill also strengthens the penalties to more effectively crack down on white plate cars, safeguarding passengers and legitimate and compliant personalized point-to-point transport services. Under the existing legislation, drivers convicted of illegal carriage of passengers for reward may be imprisoned and fined. They may also be disqualified from driving for a period of time. To enhance deterrence, the bill stipulates that the disqualification period must not be less than 12 months and may be up to 3 years. The bill also stipulates that if a licensed platform arranges for vehicles or drivers without permits to provide ride-hailing services, in addition to the relevant vehicle owners and drivers being liable to imprisonment and fines, the licensed platform will also bear criminal liability. Under the existing legislation, upon conviction of a driver for illegal carriage of passengers for reward, the Transport Department may temporarily suspend the license of the vehicle involved and impound the vehicle for a period of time. We propose to strengthen the arrangement for temporary suspension of the relevant vehicle license and impounding of the vehicle, such that when a vehicle is suspected of committing the offense of illegal carriage of passengers for reward, even if the driver involved cannot be identified for criminal prosecution, there will still be a mechanism to temporarily suspend the vehicle license and impound it. The government is finalizing the details of the specific procedures and actively carrying out the relevant legislative drafting. President, when promoting the regulatory framework for ride-hailing services, the government has always adhered to the principle of people-oriented, healthy competition and coexistence and complementarity. I believe that the introduction of the regime will help reshape personalized point-to-point public transport services, making them more modernized with younger drivers and more diversified choices for the public. The government will fully cooperate with the Legislative Council's scrutiny work and earnestly urge members to support the bill. I know that we have a tight timeline. I undertake that my team and I will fully cooperate and respond to LegCo members' questions in a very speedy manner. Hopefully, with the support of the members, the bill can be passed before the end of this Legislative Council session. President, I so submit. I now propose the question to you that the aforesaid bill be read the second time. In accordance with the rules of procedure, the second reading debate is adjourned and the bill is referred to the House Committee.